today we are having the meeting, the conversations between the American scholars and Indonesian scholars to talk about the constitutional court and the judicial power between the country, Indonesia and United States of America. The Honorable Professor Susi Dwi Haryanti and also Stephen and the others beloved participants today. This is the annual event organized by the Pusako, the Center for the Constitution Studies, to welcome and to give the introductions or orientations for the intern students from abroad every year. Today we have Stephen Amendola from the William and Mary Law School. Prof. He is the PhD, the GD students under the supervisor of Professor Christy Warren. And we also have one newly selected interns from the undergraduate student in Groningen, but maybe kayaknya belum gabung sih. Mungkin sebentar lagi dia akan gabung. His name is Raihan Kuizwin. He's from Indonesia, but study in an undergraduate program at the Groningen University. Maybe he will come and join with us today. So without further ado, today we will talk or discuss regarding the issue of judicial power or judiciary power and the judicial review authorities between the Indonesia and the United States of America. Professor Susi Dwi Haryanti will deliver his presentation regarding the Indonesian judiciary power and judicial review authorities. Then it will be followed by Stephen Amendola to speak and to give us the lecture regarding the same issue, judiciary power and judicial review under the American Constitution's perspective. After the discussion or the presentations, we will have the Q&A, question and answer sessions with the panels. So if anyone here wanna or interested with this issue and want to ask the more deeply regarding this issue, you can use the chat box to write your question down there, or by using the picture of raised hand if you wanted to ask to the panelists directly. So without further ado, I will give the microphone and also the share screen to Professor Susi Dwi Haryanti first to speak around maybe 30 minutes. After that, it followed by Stephen 30 minutes. So the times and the microphone is yours, Prof.
Okay. Thank you. Good morning, everybody, and good night for Stephen in USA. It is nice to meet you. This is our first time of meeting, and I hope that you enjoy your internship with Pusako. And thank you for Pusako for inviting me to give a very brief explanation about the Indonesian Constitutional Court and Judicial Review. And this is, I think, for the several time I was invited by Pusako. And again, once again, thank you for giving me the opportunity to join with the internship program conducted by Pusako. And good morning for everybody. I see here Bang Charles, then Dr. Edita, and then Mas Beni Kurnia Ilahi, Ilahi, and anything else. I want to share my PowerPoint.
Yes.
Okay. Yeah. Okay, my presentation title for this morning conversation, I give the Constitutional Court and Judicial Review. Perhaps I have to expand my PowerPoint. Okay. For the introduction, we know that during the Western history, throughout the Western history of thought, I think one of the main issues in politics and constitutional law has been the problem of how to control government. And then this raised the issue of the constitutionalism, by which it means that we want to have the limited government. And we know that there are several ways of control. For example, we use the doctrine of separation of power, and then federalism, representation, accountability, and the control of the action of government conducted by an independent judiciary. And then, as a result, we have the several types of judicial review. And one type of this is judicial review of legislation, in addition to review of the administrative act. And now we move to the question, why judicial review? And from the point of view of democracy, then the most important question is that how can unelected judges can give, sorry, I should have to expand. Yeah, it's a bit, okay. I think that, yeah. I think that how can unelected judges who lack democratic legitimacy overturning enacted decision made by democratic assembly? And I think this is one of the most important question or fundamental question that raised by a democracy scholar. So how can unelected judges who lack democratic legitimacy can overturn the enacted decision made by democratic assembly? In this way, the parliament and then or the House of Representatives. But again, the politics scholar argued that judicial power comes at the expense of representative institution. And one of the prominent political science that gave the argument is that Robert Dahl in 1989. And then from the democracy aspect, judicial review is not only unnecessary, but in fact, suspect. And I took from the book written by Tom Ginsburg in 2003. So in this book, Ginsburg explained that from the democracy aspect, judicial review is not only unnecessary, but also, in fact, it's suspect. However, the legal scholar try to find the argument from the different point of view in comparison to political scientists. And from the legal aspect, then judicial review can be seen as a check on the majority power. So judicial review can strike down statutes that enacted through poor deliberation in a political process that dominated by the majoritarian. And then why this can happen? Because poor procedure can create substantive as well as procedural problems. This is what happened again in Indonesia. And thus, the judicial review can ensure that minorities remain part of the system and bolster legitimacy. And finally, it can save democracy. Again, I took this argument from Tom Ginsburg book. And now I move to the historical background of judicial review in Indonesia. I think unlike in the United States, the BPUPK, or Investigating Agency for Preparation for Independence in 1945, had already debated about the issue of judicial review on the basis of the question whether or not Indonesian judiciary will give the power of review on legislation or review of the lower regulation. And one of the prominent that supporting the idea of judicial review in Indonesia is Muhammad Yamin. And as you know, Stephen, Muhammad Yamin is a prominent and accidentally, Muhammad Yamin, both as the founder of the Andalas University and also my university, Pajajaran University. So I think that we often, and then Bang Charles, as well as Bang Ferry Amsari, have a conversation, a small conversation that, okay, we have the same father, that is Muhammad Yamin, because of Muhammad Yamin once give also the honorary professor from the Universitas Pajajaran. At the time, Muhammad Yamin argued that the Indonesian Supreme Court or the Supreme Court should give a power to review legislation. At the time, Yamin used the nomenclature of comparing legislation. So rather than reviewing legislation, although he gave the nomenclature of comparing legislation, but I think most of the legal scholars in Indonesia do agree that Yamin referred to the legislation review or legislative review in this way. And however, Supomo, one of our founding fathers also, and the drafter of the Constitution, rejected Yamin proposal that based on practical and conceptual reason. So at the time, Supomo rejected the idea that proposed by Yamin by giving the two arguments or the two reasons. One, the practical reason, and the second is the conceptual reason. The practical reason refer to the limited number of the lawyer in Indonesia. So at the time, Supomo made a clear explanation that in Indonesia, we still lack of lawyers. And that's the practical reason. In addition to practical reason, Supomo argued that based on the conceptual reason, that the proposed constitution will not apply the doctrine of trias politica or the doctrine of separation of power, but rather the proposed constitution will apply the doctrine of the MPR or the Majelis Permusyawaratan Rakyat or the People Consultative Assembly as the highest institution. So the supremacy of the MPR rather than the doctrine of the separation of power. That's the two reasons made by Supomo in response to the Yamin proposal of judicial review in Indonesia. And after independence, I think that the first act or the first law regulated the judicial review was firstly adopted by law number 14 of 1970 regarding the judiciary. Through that law, the Supreme Court is given the power to review the lower regulation, such as governmental regulation, presidential regulation, and then ministerial regulation, as well as, for example, the local regulation. And this is one of the most important, we find one of the most fundamental question regarding how about the review of legislation. Who has the power of reviewing the legislation, or at the time, who has the power to review the MPR decree? Because in reality, the People Consultative Assembly also had power to establish or to adopt its decree, and what we call is ketetapan MPR. According to the hierarchy of law in Indonesia, the 1945 Constitution, it placed as the highest regulation in Indonesia, followed by the ketetapan MPR, and then the law, and at the same level is the regulation in lieu of a law or in lieu of a statute that we call here in Indonesia peraturan pemerintah pengganti undang-undang or Perpu. So this is the history after the Indonesian independence in relation to judicial review. As a result of the amendment of the 1945 Constitution, then Indonesia established a new institution that will have power to review legislation, and this is regulated in Article 24C, that granting powers of legislative review to the Constitutional Court. Okay. And now we move to the article of 24C of the 1945 Constitution. The paragraph 1 say that the Constitutional Court shall possess the authority to try a case at the first and final level, and shall have the final power of decision in reviewing laws against the Constitution, determining dispute over the authorities of state institutions whose power are given by this Constitution, and then deciding over the dissolution of political party, and deciding dispute over the result of the general election. So this is the power that regulated by the 1945 Constitution in a paragraph 1. And then we move to paragraph 2 that say that the Constitutional Court shall possess the authority to issue a decision over an opinion of the DPR concerning alleged violations by the President and or Vice President of the Constitution. So we know that based on the Article 24C, paragraph 1, the Constitutional Court will have powers such as reviewing legislation, then deciding the final result of the general election, and then deciding the clash of the state institution, and also the dissolution of a political party. But paragraph 2 not only give the power, but I think one of the obligation of the Constitutional Court that given by the Constitution, that the Constitutional Court should issue the decision over an opinion of the DPR concerning the alleged violation made by the President or Vice President of the Constitution. So, and then because of the Constitution regulate in a very general way, then the implementation of the constitutional norm given to the law or to the statute, and we already have 3 statutes. The first law is law number 24 of 2003 that then amended by law number 8 of 2011, and the most recent is the law number 7 of 2020 regarding the Constitutional Court. So this is that we call as the organic law. What is the organic law? Based on the theory of legislation in Indonesia, the organic law is the law that the enactment of the law or the formation of that law is instructed by the Constitution. So from that point of view, I think the subject matters contained by such organic law to some extent have a same value of the subject matter of the Constitution. And this is the main subject matters regulated by that law. The first one is powers of the court. again, the law made a reference to the 1945 Constitution, in particular, Article 24C, paragraph 1 and 2. The second subject matter that regulated by those laws is about the organizational matter. For instance, how the filling process of the Constitutional Court judges and that the elaboration of the constitutional norms, or the derivation of the implementation, the further implementation norm that come from the 1945 Constitution. And then the third one, and I think this is, even though this is the last subject matter, but I don't think so that this is the least important. But this is a very important law on procedure that are regulated also by those laws. I think in recent years, there are a discussion on whether or not law on procedure should be excluded from this law, and finally, law on procedure should be regulated in a particular law. So this is not, I think this is a good idea. This is a good proposal. So we can have a quite detail of law on procedure of the Constitutional Court. And then we focus on the judicial review, and we have two types of review conducted by the Constitutional Court. The first one is the substantive review, and the second one is the procedural review. I think the issue of the substantive review was not quite, although the substantive review was also important, but in recent year, most of the legal scholar begins to put their attention to the procedural review. One of the main issue here that the DPR in the last 5 years, I think, practiced a very if I can call that's the poor procedural process in terms of lawmaking in Indonesia. So maybe you have information about how the people are not quite happy with the work of the DPR when the DPR enacted some of the important legislation in Indonesia. To name a few, such as the legislation or the act regarding the anti-corruption, or what we call the KPK. And then also we can find in the enactment process of the law on the Constitutional Court, such as Law Number 7 of 2020, and then also the establishment or the adoption of the Undang-Undang Cipta Kerja, or the job creation, law on job creation, that use the omnibus method. This is the very critical situation in Indonesia in terms of procedural lawmaking, as the three law that I mentioned before showed the very destructive, if I can say, a very destructive in terms of the implementation of the rule of law principle as well as democracy in Indonesia. Why there is a very destructive to the democracy? Because in the lawmaking process of the three legislation I mentioned before, the public participation is not applied in a maximum level. So in addition, the Indonesian people are not quite happy because we still face the pandemic era. But the government and the DPR agreed to adopt a legislation that will play a very significant impact to the Indonesian people. So I will focus now on the problem of procedural review in Indonesia. I think the first one, or the first problem of this such of review is the lack of detailed constitutional norms. The 1945 Constitution regulate a very brief norms in relation to lawmaking. So we can find, or we can refer to the Article 5, paragraph 1, then Article 20, and then Article 22A. So that's the three constitutional norms that form the procedural process of lawmaking based on the Constitution. And moreover, the Article 22A only give a very general and give the further detail regulation in terms of lawmaking process by legislation. That's what we call, that I call as the organic law. And we have law number 12 of 2011 regarding the formation of legislation and regulation in Indonesia. So this is the first problem, lack of detailed constitutional norms. If I compare with Australian practice, I think Article 51 of the Australian Constitution have an opening clause, that say the Parliament of Australia should enact law that just peace, that law ensure just and peace. So that's the one of the important function of the opening clause of Article 51 of the Australian Constitution. So once the High Court of the Australian conduct its power to review legislation, then the court will use the opening clause of the Constitution to make to value or to assess whether such legislation in contravention with the Constitution. And the second problem is the interpretation of due process of lawmaking. I think although it is not in detail, but I think law number 12 of 2011 has already regulated in a very quite good norm in relation to the lawmaking. In Article 5, that law say that there are a number of principles that should be complied by both of the DPR as well as the president of those institutions involved in a lawmaking process. And one of the most important principles is that the principle of transparency, and then the principle of the benefit of the legislation. And one principle that also important is the principle of public participation. However, I think that when the Constitutional Court apply its power to conduct a procedural review, to some extent, that the judges apply a very what I call the very restrictive interpretation. And this is what can be seen in a recent decision number 79 of 2011. This is the decision in relation to the procedural review of law on anti-corruption commission, in which the Constitutional Court wholly rejected the petition put by the petitioner. So this is, I think, this is one of, if I can say, one of the worst decision made by the Constitutional Court in terms of the procedural review. And the second problem is about the valuing evidence. How the Constitutional Court judges will value evidence that come before the Constitutional Court. And this is the problem of balancing and weighing. So if two principles are in conflict, so it is quite important, and it is fundamental. It is a must for every judges to make or to value or to balance or to weighing the principle based on what is the most important situation or the most important problem that should be solved. For instance, I read from Aharon Barok books, Judges and Democratic Era. Barok say, for instance, if a judge face the conflict principle, such as the principle of freedom of speech and the principle about the national interest, which principle should give the priority, should be given the priority. So in that way, I think that if applied to the Constitutional Court judges, in particular in decision number 79, I have the opinion that the Constitutional Court judges did not apply the balancing and weighing principle when they value the evidence that come before the Constitutional Court. Based on this decision, or when I read the decision, most of the Constitutional Court only give a more value to the evidence that put forward by the DPR as well as the president. But regretfully or sadly, even the judges of the Constitutional Court did not give any consideration on the evidence that put forward by the petitioner. And finally, this is the challenges that faced by the Constitutional Court, or mostly faced by Indonesia. The first challenge is that how will the Constitutional Court place itself within the constitutional system based on principles of the rule of law and democracy? This is the very important question, because the place of the Constitutional Court within the constitutional system that based on the principle of the rule of law and democracy will not only determined by the external factor, but most importantly, it is also determined by the internal factor. And in this way, the internal factor refer to the Constitutional Court judges. So I think why I raise this question, because the constitutional, the feeling of the Constitutional Court judges' position made through three channels. The first one through the DPR, and then the second through the president, and then the third one through the Supreme Court. So each of the constitution each of these institutions can propose the Constitutional Court judges. The two institutions, the DPR and also the president, is the political institution. So I think the appointment of the Constitutional Court judges will receive what I call the politicking process. And one of the article or one of the book or article that I written, I think that written by Ran Hirsch and Nona Garupa, said that actually the Constitutional Court judges is a political actor. So I think if this is true, that the Constitutional Court judges is a political actor, then we will face a very important question: how the political actor then can play its important role to uphold the principle of the rule of law as well as the principle of democracy. So this is the first question that should be answered if we want to see in Indonesia that the Constitutional Court will play its significant role in terms of in relation to the protection of the principle of rule of law and democracy. And then the second question is, how will the political system support the Constitutional Court? As you know that many statutes are the product of the political institution. And in the making process, then the political party will give the competing aim that influence the lawmaking process. And this is very clear when the DPR as well as the president involved in the procedural process of law on job creation. And you know that most of, maybe nearly to 40% of the members of the DPR in Indonesia is the entrepreneur, come from the business people. So I think that this will also give a very significant influence when the DPR apply its power to create a legislation in Indonesia. So I think the political system that can support the Constitutional Court should be the healthy political system. If the political system is very bad or very bad, undemocratic political system, so how can undemocratic political system can give a strong support for the Constitutional Court? I don't think so. So this is the most important challenges faced by the Indonesian people right now. Thank you, Mas Ari, and thank you, Stephen, for giving me the opportunity, the first opportunity to present my very simple thought in this morning. Thank you.
Okay, thank you so much for the grateful presentations made by Professor Susi Dwi Haryanti. For your information, particularly for Stephen, because Professor Susi no need to be introduced more in Indonesia because he's quite prominent lady professors. But I have to say to you, Professor Susi Dwi Haryanti obtained the undergraduate program at the University of Pajajaran, Bandung, Indonesia, then obtained their Master of Law at Melbourne University and PhD holder from the Melbourne University. She also the chief of the comparative constitutional law studies in Indonesia. Is quite the same positions with the Professor Christy Warren in United States of America or William and Mary. Okay, I think before we go to the Stephen, I would like to remind last year's in the 2020, we also have the same discussion or similar discussions regarding the topic of judicial power and judicial review between the Indonesia and United States of America, where the the panel speaker is Professor Susi Durhanti and also Professor Christy Warren. At the time, we're trying to address or emphasize the issue of justice tenure because it is one of the hot topics at the time. And today's dialogue, we're trying to emphasize the issue of kind of judicial review conducted by the Constitutional Court of Indonesia. As mentioned by Professor Susi, we have two kind of judicial review made by the Constitutional Court. First, the substantive review, and second, the procedural review. And also there is the hot topic or hot debate between the scholar in Indonesia regarding the issue of procedural review in Indonesia, as mentioned or as explained by Professor Susi Durhanti. And 3 days ago, I think we already celebrate the 18 years old of the Indonesian Constitutional Court of anniversary. And tomorrow is our Independence Day. So August is a very important day for the Indonesia actually. So without further ado, I will give the share screen and also the microphone to Stephen to talk about the issue of Constitutional Court in America, of course, Supreme Court of America, because American didn't have this Constitutional Court, and also the judicial power under the Constitution of America. So feel free to use the share screen and also the microphone. Then to all participants, if you have the interested questions regarding this issue, feel free to write your question down under the chat box or by using the raise hand picture if you would like to ask to Stephen and Professor Susi Durhanti directly. So again, the microphone and the share screen is yours, Stephen.
Thank you very much. Honor to present once again. It's an honor to present with you, Professor Haryanti. Thank you very much for having me along too. I won't be using a share screen. I find just personally, I don't like to speak from visual aids. They don't happen to help me in particular. Yes, the issue of judicial review in the United States Constitution is a fascinating and a very ancient one because the United States Constitution does not actually give the power of judicial review. It's not expressly mentioned in any article of it. The power of judicial review, it was inferred in the early history of the Republic by the Supreme Court itself. Our Supreme Court has the power of constitutional review, and we have no separate court for that. That Article 3 and 6 together of the United States Constitution, the first which makes the Supreme Court, the one Supreme Court, the Supreme Court of the land, and that all judges underneath are obliged to observe the laws of that land. And then from Article 6, that the Constitution itself is the supreme law of the land, that it is the, in one sense, a component, well, actually, it is literally stated in another piece, that it is the organic law of the United States, as you mentioned, among a few other documents, and that it is fundamental to the structure of the Republic. So it can be inferred that being a natural part of the hierarchy of laws within the United States at its top, that anything in contradiction to that simply must be reviewed by the Supreme Court, because the judges, being obliged under Article 3 and Article 6 to obey and apply the laws of the lands themselves, have no choice but to enforce the Constitution anytime another law might come into conflict with it. But of course, several of the same issues arrived that you mentioned, Professor, that people feel that there is a counter-majoritarian difficulty, is how they say it in the U.S. political rhetoric generally, that the Supreme Court is not consisting of elected officials, that they often go from arcane academic sources, that they speak in language that common people can't understand, and so that it doesn't represent the interests of a democratic society, particularly at moments when their decisions are less popular. So these are the general issues that come up, and they also talk about judicial activism, is what we like to talk about, that that a judge in construing a law as in violation of the Constitution before striking it down, or an administrative practice, or whatever the case may be, that the Supreme Court strikes down, and actually all layers of our courts can strike down the laws as well as the Supreme Court. The Supreme Court simply has the highest of all authorities to do this stuff, and the original jurisdiction on those questions which it is given. But the intellectual history of why it functions that way and why it becomes such a regularly used power under the United States, though it's never expressly given as a power the Supreme Court has, starts earlier in history than the founding of the United States itself. The way that the Supreme Court has historically and sometimes even today ruled on constitutional questions, ruled on the invalidation of laws passed by our Congress, relates to a concept that's generally referred to as rule according to a higher law. Similar principles are referenced in the Indonesian constitution, but when we talk about a higher law in the specifically Western tradition of law, we're going all the way back to the Roman period. And then specifically, the rediscovery of a Roman law document called the Corpus Juris Civilis, or 4 documents that are called that by later scholarship, which are reinterpreted by medieval scholars in the 1100s. And the way they think about states as entities is fundamentally different at this time. The Peace of Westphalia has not yet been signed, so you essentially have the Pope of the Catholic Church and the Holy Roman Emperor, or the Byzantine Emperor, depending on where you were located. Between the two of them is intended to be divided the temporal and spiritual power for the entire planet. The fact that other states laid claims to either their own territory or similarly to planetary claims, like in simultaneous points in time, as the Holy Roman Emperor was claiming to rule the entire world, so was the Emperor of China. But enough non-communication happens between them that it doesn't arise, and I'm sure they would bring vehemence to waylay their claim if it did come up. So once they rediscover these older Roman law documents, the medieval scholars start looking at them and saying, these are so well reasoned, and they come from that temporal authority which we have lost, the perfectly reasoned Roman law, that they're able to reinterpret it for their own context, which is a concept I'll get to later, is something that they must necessarily do, because there isn't a cognitive way, there isn't any possibility whatsoever, just in a human mind, to in fact rediscover exactly what they were thinking in the 6th century when they wrote the Corpus Juris Civilis. And so in spite of the fact that it necessarily is their own reasoning, they've formed this discipline of medieval Roman law, and the states being not so distinct and rigid concepts as we have of them today, they severally consider themselves bound by this, influenced by this, to varying levels of intensity. But even under a very literal system, you had many nations under Europe, many kingdoms, but they were all Catholic kingdoms until the Protestant Reformation. And in spite of having no direct temporal fealty to the Holy Roman Emperor, the Holy Roman Emperor still being considered the ruler temporal of all Christendom, was still considered able to place legal obligations upon states that he did not directly rule, so long as they were Christian. Otherwise, if they were not Christian even to begin with, he would consider that a basis on which to declare war. It's through this scholarly process that a few different traditions emerge. You have the Roman law such as practice, and then you from that eventually get the civil law. The canon law of the Catholic Church is evolving at the same time, and then the common law of English systems and systems descended from it, such as the United States constitutional and judicial system. So these concepts are all developing in similar time periods going back to the 12th century, and some of the scholarship overlaps. So there is a great scholar of canon law from the 12th century, a British fellow named Gratian. And although he's writing for the canon law, many of the concepts he writes there get directly integrated into the English common law just by their influence, their persuasiveness. So we have laws that are actually directly coming from the religious principles of the church, and then they are getting implemented into secular law, because the notion that there's all that much of a distinction is fairly limited to begin with. All of society is necessarily Christian and necessarily subjected to the See of Rome, or else after the Great Schism, Byzantium itself. But this ties in because the very notion that you must invalidate a law if it is in contradiction to the higher law of the Constitution comes from Christian reasoning. Or at least in the Western tradition, there is a strain that goes back to the earliest theologians of Christianity. I'm sure the same idea can be found elsewhere as well. But yes, Thomas Aquinas, who was considered a great theologian of the medieval period, and who I'm sure you're familiar with, he writes about erring reason in his document, the Summa Theologica. And that principle is, if I'm a Christian person and I believe, based on the way I understand the principles of the Christian religion, the way I understand morality, which also falls under his concept from the philosopher Aristotle, that reason, the ability to think itself, is the way we comprehend any of this, and that also this sort of metaphysical objects that he describes, the reason of the mind, is a thing that is descended from the divine reason of God, also related to the concept of logos, or the word, which is also the person of Christ or God the Son, as the Christian tradition would have it. And so all people, however mean their understanding, however poor their education, under Thomas Aquinas' conception, are said to occasionally, by the goodness of their reason, be able to access the word and truth of God. And that because that process happens through reason, that one must obey their reason. And the question is put to him in the Summa Theologica, well, what if, as so often happens with people, that their reason is faulty, that they believe something evil to be good, and so act accordingly? Would this, because it is intrinsically evil, not be evil in the ultimate and evil somehow for their reason to understand that way? But Thomas Aquinas says no. And he actually quotes directly from Aristotle, who says that, properly speaking, the incontinent man is one who does not follow right reason or correct reason, but accidentally, he is also one who does not follow false reason. And this concept is used in what the Catholic Church now calls the primacy of conscience, which is the idea that you must obey that which you are able to reason about your understanding of the moral laws of Christianity. And this basically is directly inherited into what we now think of as the English common law and the US judicial system for which that descends. It just gets sort of divorced from the rest of it once we have the Westphalian notion, in which states are now much more distinct entities, no longer have obligations to other states into which they have not voluntarily entered, that their sovereignty is as rigid a thing as that. So once England and eventually the United Kingdom get isolated in this more Westphalian system, having inherited all of these notions of the universal law, of the way Christian moral reasoning works, of rule according to the higher law. And this is something that Augustine, the theologian, says himself, just as a thought exercise. He says, you know, if you are obeying the command of a lower proconsul of Rome versus the emperor, just naturally, because the emperor is higher in authority than the proconsul, if the proconsul's dictate is contradictory to the dictate of the emperor, then you must follow the emperor, in spite of the fact that the proconsul has authority over you, just as a statute has authority over you, even if it is contradiction to the Constitution. But the difficulty with this is that, say, you are under the impression that the proconsul is correct, and yet he is not. You still cannot violate your understanding, because then you will be violating your understanding of what is the case, be the law of the emperor himself, or analogously the Constitution. Now, the tradition that develops in Britain after the Westphalian notion starts applying this concept more aggressively and more secularly to the common law itself, its own version of the jus commune, or what came from the Roman law, the notion that there is sort of a general cognitive environment, a new sphere in which the law is something debatable. It's something that the courts, they make various decisions about. The judicial opinions are not themselves laws, but they're fairly good evidence of the law. And so we quote several of them so as to have a precedential environment, so as to make detailed constitutional norms, although in the case of Britain, an unwritten constitution, but just as you were saying, they start over the course of hundreds of years having, you know, very long lists of cases that just, they represent, look, 100 cases were decided on this fashion. Its reasoning still strikes me as good, so it does seem to be the common law. But then furthermore, if they did just have a really good argument, if they just came along one day and said, no, in spite of the fact that the common law has traditionally understood this, my argument that this is inconsistent with the other general principles of the common law should overweigh this. And depending on, you know, how high they were in the relative hierarchy of the courts of England, then that could be sustained. Or it might get politically overturned depending on the political realities of the situations. Judges are, in fact, always political actors to whatever extent they permit themselves to be. And one interesting thing that occurs during this period in England is that constitutional review of a sort can be done by ordinary people, not by any legal procedure, but simply because of the political reality. And this is a distinction that's made even to this day in English law, that there is a distinction between legal sovereignty and political sovereignty, that some institution under their government might have the legal sovereignty to do anything, but if in practice they can't actually get anyone to obey it, then that it's not political sovereignty over the issue. It just can't be done in practice. So there was this one fellow, John Lilburne, he discovered in a rather ignominious but also heroic fashion that a single individual could exercise a form of political sovereignty when he was brought in for charges of bringing in books from the Netherlands that it would have been a violation of the law to do. This institution, this court that existed at the time called the Star Chamber, wanted him to testify against himself, to serve as a witness against himself that he had brought him in. And he, simply by pure reason, which is the basis of what both the canon law, the Roman law, the civil law, and the common law think of as, at least in their earliest history, the origin of the natural law, the highest laws that can be found. One can only come to the capacity of God by the use of their reason. He says, no, a free-born Englishman has no obligation whatsoever under the law to incriminate himself in a court. That wasn't written anywhere in the law at the time he said that. And in fact, the Star Chamber tortured him publicly for a long time in a horrible fashion so as to extract his self-incrimination, but he still refused. But this eventually caused a great enough political upheaval that the Parliament abrogated the Star Chamber, completely dissolved it, and in fact constitutionally established within Britain the right against self-incrimination, which now appears in the US Constitution as well, simply by its persuasiveness. So when judicial review is exercised in the United States, it's always a process somewhat similar to that, and the sources of authority can get somewhat confused, because what a judge is really doing when a case and a set of facts is before him, or her or them, or whatever the case may be, they are weighing all of the relative factors, all of the relative factual situations, all the laws that might conceivably apply, but in several circumstances, perhaps not all the relevant precedent has even been brought to them, or perhaps even if it is, it's sort of cognitively difficult to keep track of, particularly if you do have an aging state in which the number of things which might be legally relevant or persuasive is starting to be an overwhelming matter. And ultimately, if you think closely, and in fact, cognitive scientists, cognitive linguistics, psychologists, Bayesian rationalists who employ abductive reasoning, they sort of do studies on how the minds of people work. And in their sciences, they've sort of found, like, while the judge is intended to have procedural standards of review, a particularly good memory of a uniform doctrine of constitutional norms which have preceded them in the stare decisis, a great and plain knowledge of all the statutes that arise in the case, it ultimately comes down to certain types of thresholds. At some points, they just sort of weigh the scales with all of these factors in their head, and they have to come out and put out a phrase. And the interesting thing about this is that while natural law is no longer accepted by any US court, it's not recognized in the Supreme Court, they never talk about it anymore, they are still using sort of a generalized moral reasoning. Anytime they say, oh yes, the Constitution, and it's sometimes they even say, and its general principles, the principles upon which it was founded, the way it was meant to be morally constructed, the type of free citizen it was meant to create, cannot tolerate this particular law, even though there might not be something directly in contradiction to it. And sometimes that sort of thing gets the most harshly criticized as being counter-majoritarian, as being in some way undemocratic. And yet sometimes these decisions are the ones which best preserve the rights of minorities and so forth. So how the power of judicial review initially forms, because I'm going to talk about the distinction between the way a judge must in fact reason in practice, with everything we know about cognitive science, and then just the actual sources of the law that lead to the US Constitution. So we'll begin there. There was a case in 1610 in England called Dr. Bonham's case, in which Sir Edward Coke who wrote the Institutes of the Laws of England, or a response to responsible on Littleton. He was a great jurist, and he's far more influential now in the United States than he ended up being in Britain, where they prefer William Blackstone. He has a case before him, and while the basis on which he decides the case is actually a far more practical point, he says in general about the absurdity of the law on which he's ruled and its own contradictions. He says, one cannot be judge and attorney for any of the parties. And it appears in our books that in many cases, the common law will control acts of parliament, and sometimes adjudge them to be utterly void. For when an act of parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it, and adjudge such an act to be void. Now, this was partially criticized even at the time. It was considered a violation of the British doctrine of parliamentary sovereignty. The king himself was not pleased to hear anything like that, but it remained an influential point, remained a point that some people think this is the basis on which the framers of the US Constitution thought by the time they were around that judicial review was a very natural practice. The first case, well, the case which is usually said to be the origin by the Supreme Court itself of its doctrine of judicial review is called Marbury versus Madison, which is a case from 1803. Now, the common record about that is actually slightly wrong. There were actually many cases which occurred before that in various states, in the Supreme Court itself, and prior federal court decisions of previous constitutions, all of which employed judicial review as a concept in invalidated statutes. But this is one where the doctrine about judicial review gets described in a fairly particular way, which also gives people, because there was a lack of detailed constitutional norms this early in 1803, sort of a better idea of how they believe the republic will work. But an interesting thing about Marbury versus Madison is that it pertains very closely, sort of to a corrupt arrangement, sort of to a political struggle, just to the Judge Marshall himself, who actually went to William and Mary, where I attend, trying to make the decision specifically around the perceived power, the practical and political sovereignty of the court, and its relative power to the president and the legislature of the United States. What happens is he's been asked to issue a writ of mandamus, or a writ for a mandatory action that the Secretary of State deliver the commission of a judge of the previous president to the fellow who's waiting for that commission. And but the new president's already in power. His party is already going to be dramatically less popular very suddenly, at least in the next immediate period. And if he issues that writ, it is not likely that the Secretary of State is going to obey it, because he simply does, in spite of being the Chief Justice of the Supreme Court, does not have the practical authority, does not have any means to force the Secretary of State to do that. The Secretary of State might very well not comply, and had very important political reasons not to. And in fact, that's how the case arose already. The Secretary of State, in spite of having legal obligations to issue the commission to Marbury, did not deliver it. So he wrote very carefully in the opinion, went through every step. He first says that, well, on the question of whether the Secretary of State should deliver the commission to Marbury for him to be a judge, it is illegal for him to refuse to deliver it. But when Congress wrote the Judiciary Act establishing the terms and rules of the Supreme Court, they wrote it in this way that can be construed, that I have the power to issue a writ of mandamus upon an officer in the executive branch directly. But actually, this provision is unconstitutional. And in fact, the Supreme Court, have the power to rule things unconstitutional. He first lays out the doctrine for that. And so, in spite of the illegality and shamefulness of the Secretary of State of my opposing party's actions in not delivering the commission to the Honorable potential Judge Marbury, I am without the power to do that, because I am, in fact, greatly empowered to review the Constitution. So it was a strictly political maneuver, although likely consistent with what he already believed to be true of the power of the constitutional, of the constitutional interpretation owned by the Supreme Court of the United States. But the notion that it was actually very important to him to keep cognitive track of, oh, if I actually rule a different way, regardless of what the law says, my ability to enforce the decisions of the court will cause the court to seem less legitimate, to have less institutional authority. And so he actually found a rather ingenious way, right to the center of all that law and opinion, to say, well, while that is wrong, I am endowed with great power, and henceforth always will be. And he sort of lays out the doctrine on which it's based. But then, because there was a fairly aggressive action, a very political one that caused a bit of backlash on that being, the justices being direct political actors, as you mentioned. Another decision invalidating a law of Congress specifically was not issued for 50 years after that. There were ones in between invalidating state laws. The next one after that was Dred Scott versus Sanford. That was another much maligned decision, and there weren't all that many constitutional norms saying how they should be going about voiding U.S. congressional statutes, because it had only been done once before. That was the one where, right before the U.S. Civil War, they said that regardless of the validity of the slaves' case, that the constitutional notion of citizenship was not meant to include Africans, and so he simply cannot make the claim. The Civil War followed not too long afterwards. Then thereafter, there were a few other cases. There's the sort of cognitive tradition I'd like to talk about, because after Marbury versus Madison and Dred Scott versus Sanford, there's really no practical question that the Supreme Court, under the Constitution, in spite of it not being expressly mentioned in the U.S. Constitution, has that authority and now regularly uses it. They've validated some near 500 statutes since the beginning of the Constitution by a recent year. But there's one case called Swift v. Tyson, and this pertains to procedural laws about judicial review under the Supreme Court. This is written by Joseph Story, and pertains to a New York financial. It's an internecine case, but the ultimate thing for which the case is remembered is that Joseph Story says that when you bring a case under diversity, which means that it's brought to the federal court's jurisdiction by there being citizens of different states, you must apply any state law which is written in statute, which is almost like a civil law preference. We're already getting closer to a civil law rather than a common law system, which now the U.S. is a very interesting mix of those two things. But on any construction of the common law that the state has brought to bear on that issue, the federal court is under no obligation to follow that. There's simply the federal common law. And he has some very beautiful sweeping language about the one true and universal law. And this is one thing that's sort of lost about the history of judicial review in the United States, is that it used to be this broad sweeping tradition in which judges sort of used the best of their reasoning power and the best of their great learnedness, and they would quote scholars of international law like Hugo Grotius and Puffendorf and things, and they would say they were trying to reach what, in their view, was the most just result, not merely by the statutes in the Constitution of the United States specifically, but anywhere there was a perceptual or cognitive gap in those things, anywhere that the law didn't seem to completely address the question. They'd say, well, the international norms, the jus commune, the laws of the sea pertaining to this, well, they go this way, and that's how we're going to apply them in order. And, of course, they're not always right about producing the most just results, and this starts to become politically unpopular about a little more than a half a century later, in which case you have a case called Erie Railroad versus Thompson. And Erie Railroad versus Thompson was a massive shift in the way judicial review worked in the United States, because up until then, right, you had learned men who could arrive at practically any conclusion about the law, but it was always reasonably well put together and came from reasonably good sources as to how the law should function, even if they were written by scholars of foreign states or of international law generally. But Erie Railroad versus Thompson comes in and just directly abrogates Swift v. Tyson, says, no, if a case that has to do with state law comes to the review of the Supreme Court, we will review it under the Supreme Court of that state's interpretation of their common law. There is no federal common law, federal general common law, which the justice refers to as a brooding omnipresence, because this has now become thought of as a source of corruption. But the difficulty with this, and the reason I mentioned, is that in spite of the fact that Erie Railroad completely revolutionized the way federal courts worked thereafter, sort of made them a little more stable, but a little more staunch, procedural, a little less interesting, a little less obscure in their references. There was this one professor in the United States named Stephen Sachs. He writes a law review journal called Pennoyer Was Right, which refers to another case, Pennoyer versus Neff, which is a good example of the kind of reasoning which occurred under the Swift v. Tyson regime. And he lays out, with fairly good evidence, goes across many cases shows one in which this is a post-Erie case, but the judge is reviewing an instance of a river deciding a border either of a sovereign land or of property, I forget which. And there's an international law principle not written anywhere in the law of the United States that if a river avulses and so changes the border that the river itself defines, then that being a sudden event, the thalweg of the previous river is still the border of that land or sovereign area. But if it accretes, if it slowly moves over time, then the moving thalweg continues to constitute the difference in the property of the land. Not written anywhere in the United States or under the federal common law, which doesn't exist, but it is a broadly accepted international law principle from much older sources. And this, like many other things and many other decisions, you can find being the basis of this of judicial reviews occurring under the United States. And that leads me to my last point about the whole subject is the way judicial review works for us is it sort of doesn't and can't have more specific sources of authority than that. It's almost just like the way our intellectual systems work. You couldn't have it another way. There's a concept in cognitive linguistics called the conduit metaphor versus another concept, the toolmaker paradigm. And I don't have enough time to describe them very well, but the essential argument that these contrastive conceptual metaphors pertaining to the way the English language works illustrates that for the last 40 years, linguistic scientists have said language by itself, constitutional language, I mean, they didn't specify constitutional language, but it being a subset of language, speech, writing, literature, anything, but in fact, you can infer the Constitution, the laws. None of this has intrinsic meaning by itself. The semantic content, the meaning of concepts is in here and in your mind over there. And instead of thinking of words as being things that we insert meaning into and transfer over, we have to cognitively co-construct any concept that we wish to communicate between each other, because our skulls are epistemically limited environments. They can't be penetrated. We can't, in fact, magically transform the way I understand a thing over into your understanding of a thing. And language is at best a tool for the communication of the semantic content intended. And the best you can do is keep saying more. You can just keep adding more detail, but the other person is never going to, by just so adroitly opening the conduit of the words, get more of your meaning than they could if you were simply able to keep talking, either from being alive and being right in front of them, or having contemporaneous sources, other things you've written that might inform the thing. But essentially, every time any justice of our Supreme Court or any citizen of our country or any legislature who's writing, believing that they are writing a law on the basis of the Constitution whatsoever, have a perfectly unique and utterly individual instantiation or instance of their understanding of the US Constitution. And so unless there was a body to do the judicial review, and unless they simply had the power to do that review because fiat, it was given to them by the US Constitution, somebody simply ordained at one point, they said, in order for there to be any kind of practical uniformity, however difficult that question might be, on the application of the US Constitution, we would need one Supreme Court. Now they simply sit and have that legal sovereignty. But unless they did, there simply wouldn't be a way to unify and reconcile the roughly 300 million unique cognitive instantiations of the United States Constitution that every citizen must have. But that's an interesting point about constitutions and governance generally.
Sorry.
Yes.
2 minutes remains. You only have 2 minutes remains because we want to go to the Q&A sessions after this.
Excellent, thank you. Is that every citizen of the country has to operate in some way under the legal precepts of the Constitution, if it is a constitution that is arranged such that it in fact has influence over people's daily lives, which the United States Constitution is to some extent, especially the way it's been interpreted and hallowed, as people in the United States love the Constitution, and they historically have. Not so much lately, but they used to for most of its history. And so judicial review, which is also just constitutional interpretation, is that form of constitutional interpretation which is sitting in that group of people that have been given the temporal power to say, well, my cognitive instantiation of the US Constitution is the law. And then all they have to worry about is whether or not it's going to be enforced and sufficiently institutionally recognized by the rest of the political system, if they'll have sufficient support, if the kinds of decisions they're giving out are going to be realistically followed by anyone. But then everyone else, the members of the Congress, they have to put out laws. The administrative state, they have to make decisions that they think are reasonably fair under the principles that the Constitution is meant to guide. And no two people are going to think of it perfectly alike, which is one problem of constitutions generally and their relative performance to each other. Going back to Tom Ginsburg, is the Constitution must have sufficiently persuasive language in itself and associated with it that it can instantiate in the minds of the people persuasively enough, not only that they'll understand that they will co-create that construct in a sufficiently similar way, but that they will be motivated and enthusiastic about leading their lives in a way that's going to be consistent with that political order and system. And yeah, if that's not true of your citizens, then it's also not going to be true of your politicians who are elected by the citizenry. Things start to break down in moments of corruption, like corruption happens in the United States all the time. We try to make our Constitution influential, and being roughly 300-year-old state, it's been going roughly well. But I grew up in my state of New Jersey, state very well known out of all U.S. states for corruption, and it's like this capital city of Trenton, New Jersey, is a place where the U.S. Constitution doesn't exist very much. Essentially, the people who live there have very different attitudes, and whatever realistically politically happens does. And these are the sorts of things you have to avoid just by, in fact, using that sort of divine reason, that sort of abstract noosphere, that sort of ability to communicate with everyone else in a way that on some level is fundamentally persuasive, has enough to do with human empathy, has enough to do with the interest in human comedy and solidarity and cooperation, because otherwise they just won't understand or they won't care enough. That's the Constitution of any nation is a metaphor. It does not itself constitute the republic. It is aspirationally attempting to constitute the republic by its persuasiveness. The Constitution is, of course, in however many million citizens you have, however many infrastructural systems you have, administrative systems you have, trucks driving back and forth to make sure the state functions. So right, if you want to have a Constitution, you have to make sure that it is actually a good metaphor, that it constitutes your state. And thank you very much.
Okay, thank you so much for the long explanations made by the Stephen Amendola, the intern students from the William and Mary at the Pusako, or the Center for the Constitution Studies. Before I offer the microphone to the other participants, I think does Stephen has questions to Professor Susi Dwi Haryanti regarding her presentations, or vice versa? Does Professor Susi Dwi Haryanti has the questions to the Stephen? Before I offer the microphone to Pak Charles, Bu Edita Elda, and the others researchers in Pusako. Okay, Stephen, does you have any questions to Professor Susi?
I missed some of that. You were asking if I had a question for Professor Susi.
Or vice versa, Professor Susi, does you have any questions to Stephen?
Professor Susi, your microphone is not on.
Your microphone is not on.
Sorry. Thank you, Mas Ari. Stephen, it's very interesting presentation. I will ask or raise the question about in the last section, you explained about the function of the language, yeah, because the language, the Constitution language, I think have a quite unique, that's a legal language, but have to be understood by the people, the layman, the people. And you say that how I will ask how the U.S. Supreme Court make the living Constitution, because you know that your Constitution, the U.S. Constitution, adopted in 1776 or 1789, whereas now we are living in the 21st century, and how the Supreme Court give a interpretation to the Constitution norm in order to make the living Constitution. Because as far as I know, there are two types of the Supreme Court justice. the very conservative and the very liberal interpretation, and how these two distinction type will make what I call the forum of the will make the Supreme Court as a forum of principle. So they argue about the contesting principle. Thank you, Stephen.
Thank you. That's an excellent question. In recent years, they've been saying the Supreme Court's been getting significantly more political or politicized. I don't know how true that is or how much they simply weren't noticing how political it was before, but certainly the conflicts are getting more internecine. They're getting less interested in cooperation and talking to each other in a way that they understand each other, having even a remotely similar comprehension of the Constitution. Or, I mean, some of the justices lately, they've asserted their positions on the Constitution against the whole popular will about what they think the Constitution means. So there's two levels on which they do that. One is just the level on which they claim to create the living Constitution. It's almost entirely under a single clause of the Constitution. There's what they call the substantive due process clause. And it's just one that they essentially consider flexible, intellectually flexible enough that, and this is one that comes in the wake of the US Civil War, that any sort of implied right that seems to be based on the general principles of the Constitution, which is something that you can also adapt to modern society. The things that, the United States population was very big on wanting to make marriages between homosexuals legal. I know that view is not held everywhere in the world, but it was the substantive due process clause on which the claim that, in fact, that is a right was given out by the Supreme Court. And that's almost always the mechanism they use. In fact, back in the 19th century, that same clause was used by more conservative justices to give implied rights to corporations and things, moneyed interests. And so, in fact, there was sort of an interesting flip where what we would now call conservative actors loved the substantive due process clause, and now they hate it, and vice versa. And the other is, the conservative justices who probably are best represented by the ideology of Justice Antonin Scalia, who was sort of a celebrity, the way he would write his opinions very disrespectfully, but people found it funny. He speaks of the original intent of the Constitution, that no ruling on the Constitution is valid unless it comes from a strictly 18th century view. But then he was sort of behind linguistic science, because now our scholars of linguistic science, if he were still alive, could go up to him and say, it's interesting that you have a replete constitutional doctrine that you rule on and give opinions on regularly. And if we statistically analyze them, they seem a lot like Reaganism, or the political philosophy of President Ronald Reagan, by whom he was appointed. And people, criticize him harshly for that. And he always says, no, look, it says it right here in this letter by a founding father, or in the text of the Constitution itself. It can't be interpreted another way. But that's actually just cognitively impossible. He, in fact, cannot extract from the mind of the framers an instantiation of that notion that will be the same. And it's not that he couldn't try and approach it better, but because he doesn't recognize that he must attempt to, that he must in fact go work really deeply on all the surrounding sources of the founding fathers in order to even begin to attempt that, and at which point he probably wouldn't agree with what he found. Then he has this confused thing where he's saying what is originally intended in the Constitution is the political philosophy of the president who appointed me, and that becomes internecine. But then the other side of the court, they sort of just don't take that view. They sort of just ride on the accretive constitutional norms that have gone out throughout the stare decisis of the Supreme Court history. Although the stare decisis actually didn't exist at first. That's from the mid 19th century. But it's collective record and precedent. And they don't raise strong principled objections to the process of understanding the Constitution the way you sort of best put it together yourself, and that allows the use of the substantive due process clause, and anything else they can figure out as being roughly fair. And they're not always perfect at that either. There's perfectly good political criticisms going either way as to how faithfully they're actually being to their cognitive comprehension of the Constitution versus their political will. But this is also kind of a misconception about the way law works that's just sort of held by the average US citizen. They don't realize that nothing in the law means anything until it's applied to a set of facts. And so they hear a case that happened and they're like, well, that couldn't possibly be the law. I understood something else. But of course, when they first understood something else, they're thinking about a different set of facts. And maybe if they did hear all the details of that case, they would still disagree. But generally, they don't go through the process of finding out before they're like, judicial activism is ruining the country. But yeah, unfortunately, that sharp intellectual divide between the conservative and the liberal justices, the one that just sort of have a not specifically principled ride through the precedent of the Supreme Court history, and the ones who say, no, we must actually get rid of much of the precedent of the Supreme Court history and stick to the 18th century Constitution. This is making the Supreme Court seem less institutionally legitimate. Americans no longer cherish the Supreme Court in large numbers. They are often politically outraged by its decisions. They'll more often go and physically protest and cause nuisances at the Supreme Court building. It's the process of appointing the Supreme Court justices themselves is now highly partisan and politically based. It is a degrading situation. And depending on your political perspective, not necessarily for the worst. Sometimes the degradation of political institutions is valuable for another purpose. But right, if you want your constitutional court to develop well, then you have to strongly avoid such rigid cognitive notions and allow oneself to be flexible in their interpretations.
Okay, thank you so much for the answer. I offer the microphone to the floor. Does anyone here or the participant wanna ask anything regarding this topic? Maybe
I
Pak
do have a
Charles,
question for
Bu
Professor
Evita,
Susi.
Muhammad Ihsan Alia. Hello. Sorry, I think the connection is quite bad here. Okay, does anyone here or the participant wanna add something to the Stephen or Professor Susi? Just raise your hand. I mean, use the picture or raise your hand. Okay, Anissa Salsabila, can you open your camera and your microphone?
Okay, thank you. But first of all, give me sorry that I cannot turn on my camera because I worry about technical difficulties, Prof. and Stephen. Good afternoon, Prof. Susi, and also good evening, Stephen, and also for participants here from Universitas Andalas. Let me introduce myself. I'm Salsa, Prof. and Stephen. I'm from law faculty at Universitas Bengkulu. So first, I would like to ask Prof. Susi regarding to procedural review. That I want to ask, like, in your opinion, what is the ideal paradigm that need to take by constitutional court judges to see procedural review? Because I ever read Marwar Sihaan opinion regarding these issues, that he states that constitutional injury that we will face is bigger if we reject it or cancel the whole article of the law, then we still keep the article of the law if despite we know that there is a mistake in making process. So I want to ask, like, what is the ideal paradigm that need to take by constitutional court judges to see procedural review? And then the second question for Stephen, I'm so pleased to see you today, Stephen. But I wonder, is the United States have an explanation of each article of the law? Because in Indonesia, we know that we have the explanation of each article of the law that still needs more explanation of that article still arise questions. And then we're going to make it clear in the explanation. And my question is the Supreme Court of United States able to examine the explanation of the article? Because if I have not mistaken, correct me if I'm wrong, Prof. Susi, Constitutional Court of Indonesia have ever examined the explanation of the article. So that's all my questions. Thank you, Prof. Susi and Stephen. God bless you.
Okay, thank you so much for the questions. Also, there is a question from Pak Charles Simabura on the chat box. Maybe Professor Susi and also Stephen can read the question and answer the question also. Okay, the floor and the microphone I give to Professor Susi first, maybe, and then the second one to go to the Stephen.
Thank you for the question. It's a very good question because in in several event discussion, academic discussion, I encourage more legal scholars in Indonesia now put serious attention on the procedural review conducted by the Constitutional Court. One of the most important thing in focusing on the issue of procedural review, because I think that every time we discuss about the procedure, and then the most important question is that about the fairness. So a procedure has always raised the question of fairness. So I think if Indonesia is regarded as as a state based on law, or state that comply with the rule of law as well as democracy, I think if the issue of due process is not only related to the substantive or substantive due process of law, but also the procedural due process of law. And if we discuss about the procedure, we include the discussion about procedure in the sphere of the legislative or legislative authority, and then the executive, the branch of the executive, as well as the branch of the judiciary. So I think that we have to put attention again, to put more attention, serious attention on the procedure that we face in the legislative process, as well as the executive, or in making administrative decision process, as well as a procedure that conducted by the judiciary. So that's my first argument why procedural review has the very important role within the Indonesian constitutional system that based on the rule of law and democracy, because procedure always raise question about fairness. And in terms of the lawmaking process that based on the rule of law principle, I think the DPR as well as the president cannot only rely on the issue of legality. In what is the meaning of the issue of the legality, that the DPR and the president claim that both of them have the authority to enact or to make law. But both of the DPR and the president should also comply with the other principle. Not only they claim they are the legitimate institution who can make law, but also they have to comply with other principle. What is the other principle? The other principle that also put the principle of morality, the principle of ethics, and also the principle, or they have to consider that once they make law, they have to make a very good or a qualified law. So that's what is the very good, or what is the high quality of law. The high quality of law is that the law making by the DPR and the president that in line with the expectation of the Indonesian people. So the most important thing, or the most important function of the law is that's the reflection of the people on how they want to be regulated, or how they want to be governed by the government. And the law that they want to be governed by the government is the law that will meet the expectation of the Indonesian people, in particular to reach the final aim of the Indonesian. That is to create, or to create the prosperity of the society. And then I think that the DPR as well as the president also should consider about the legal the efficacy of the law that they want to be created. So this is the one of the most important issue. So in addition to the quality, the high quality of law that produced by the legislature, and then the second issue is that the legislature should be able to raise what I call, or to make what I call, the rational acceptability. So the rational acceptability by the legislature should also be in line with the rational acceptability of the people. How if the rational acceptability of the legislature far behind or far beyond the rational acceptability by the people? There would be create a huge demonstration. That this is we see from the history, or from the enactment of the law number 19 of 2019, the law about the CAPIK, that most of the Indonesian people refuse to accept the amendment of a law, the previous law, the old law, that is law number 30 of 2003. The Indonesian people still, most of the Indonesian people still regarded that the old law, the law number 30 of 2003, still can be used properly to eradicate corruption in Indonesia. So there is no need to amend, to make a radical amendment to such law. But in reality, we can see that the legislature in this way is the DPR as well as the president want to make a radical amendment to the old law. So I think there is a conflict between the rational acceptability made by the legislature and the rational acceptability that made by the people. As a result, there will create a huge demonstration because people will refuse that law. So this is the one of the most important thing that should be considered by the Constitutional Court judges when they apply the procedural review. Because I think that in particular, if I put a critic on the Constitutional Court decision number 79, there are three reasons why I labeled that decision such a not quite good decision. The first one is about the basis. What is the basis that be used by the Constitutional Court when they are conducting the procedural review? So the basis of the review should be, in my opinion, should be unlimited. So the Constitutional Court judges should have a very good capabilities to expand all possibilities of basis that necessary for conducting procedural review. What I mean the basis here, the Constitutional Court judges cannot say, for instance, in one particular argument that made by the judges, the judges say that okay, there is no written norm that can regulate how long will the bill can be the bill ended. So the judges argue that there is no written rules, there is no written norm that can be used by the judges to assess how long is the bill will be appropriately debated. So in this way, I critique that the Constitutional Court judges seem to be very what we call a legism. So legisme in bahasa Indonesia. Why? Because the judges only rely to the written norms, only rely on the written norms instead of other basis, for example, ethics or morality or something like that. And the second, my critique also based on my second argument, that is how the Constitutional Court judges make a value when they assess all evidence come before them. In this way, I raise the question about whether or not the Constitutional Court judges apply the balancing and weighing. And the third reason why I put my critique on the decision is because the meaning, how, to what extent, or how the judges give their interpretation on the principle of lawmaking, or the principle or the due process of lawmaking. Because in my opinion, the judge's argument, the judge's interpretation is very formalistic. So this is my reason, the three reasons that I use to critique the Constitutional Court decision on procedural review. Thank you.
Okay, thank you for your response. I offer the microphone to Stephen.
Oh, yes. So I was answering the question about where, if in the United States we have explanations of laws. It sounded like what you were describing is perhaps a little better than what we have. We in fact, don't have anything very specifically, nothing so formal. If you're going to want to know the meaning of a particular law, it actually will be a bit difficult to figure out where to find that information, if it even exists. Now, there are a few different sources of that kind of information. One is in the text of the act itself, but you have to know to look there, in fact, because once the act is put out, it's printed in a few different ways, and then ultimately it's incorporated into the U.S. code or the code of the particular state, if it's a state law, and that's just actually given out in just these numbers that give you all these rules in a row, but with no explanation whatsoever about what those might mean if there's the slightest bit of ambiguity. Now, if you go and look up those laws or the act from which it comes, there might be hermeneutical or interpretive information about the meaning and the intent of that act right at the front of it. But if there isn't, then there's not a whole lot of other sources. If it's ever come up in a judicial interpretive case in which they've either had to interpret in reference to the Constitution or just its construction and application, then you would have that source of information, a judge interpreting and saying what that law means. And then also, if you're pretty good at research, you can go and find sometimes records of the actual minutes of Congress as it was talking about why it was passing these rules. Those can be found, or you can find newspaper articles that were written contemporaneously around the time of the act, debating the various things in it. But unfortunately, no, there's nothing so neat and tidy as you could go to one place and find what the meanings of the laws are. In fact, it's kind of well accepted by us that the Congress consists of 545 people or so, and they had 545 reasons for passing that law. So follow it to the best of your ability. Maybe it'll come up in a conflict, a suit, a criminal direction. If it, really is not something that you could have understood, we'll try and work with you. But ultimately, I mean, people do suffer by, in fact, as you mentioned, having insufficient knowledge of how to plan their own activities in compliance with the law. That sort of thing does come up. A lot of people can hardly figure out. It's particularly in areas of the administrative state and other things like that, like what expectations are in fact upon them from the law. Although the average U.S. citizen on a daily basis is not going to interact with the law that much. Although they say the subaltern populations of the United States, Native Americans, African Americans who are here, women as well, are subject to more legal conflicts than the original. I forget the opposite term to subaltern, but the people who founded the country. But but yeah, by and large, it works roughly well in spite of there being no formal system for people being able to understand what's written in the law. And that is a great criticism that's levied upon lawyers. People say, you lawyers, why do you even write your civil complaints the way you do? Who can understand what you even said? It doesn't even sound like a sentence in English. And yeah, it is a large problem, unfortunately.
Okay, thank you so much for your response. I'm so sorry to restrain this meeting because after this meeting, most of the researcher at Pusako has the meeting with the another person for the Constitutional Week competition event. It is the annual competitions organized by Pusako for the senior high school around the Indonesia, such as like debate, speech contest, and also battle of brain and so on and so forth in constitutional matters. So I think we try to close this meeting today.
Ari, before
yeah.
you close the session, I will also I'd like to add some my explanation why I argue that the interpretation of the judges is too formalistic. One of the arguments they make when they want to ask the question raised by the petitioner, that is the question of the usability, whether or not a law on a law number 19, 2019 is in line or can reflect the implementation of the principle of usability or the kedayagunaan in Bahasa Indonesia. The judges simply say that yes, this law in line with the principle of usability because in its elucidation, the drafter, the law, the DPR as well as the president say as a form of pembentuk undang-undang. They say in the elucidation that this law is useful for eradicate corruption in Indonesia. That simply say like that. So I think in that way, the judge is not interpret. It is not the just interpret. It is not the just interpretation, but rather the drafter interpretation. I think that the interpretation made by my judge, it is not interpretation. It's a very simple interpretation. It's a very formalistic. It is because elucidation has said that this law is useful for eradicating or something like that. So this is again one of the example, and even the judges did not consider about the situation when the law was enacted. The law was enacted in the when most of the DPR member approaching the final terms of office that we call here, and maybe in United States called the lambdaxation. So I think that in the lambdaxation, member of the DPR should restrain to give an approval of a bill that will give the radical amendment in terms of corruption eradication in Indonesia. That's my addition.
Okay.
Yeah, thank you.
Okay, thank you for the additional comment and explanation, Professor Susi. For your information, 2 weeks ahead, we also have the meetings, the constitutional conversations with the former constitutional justice, Palguna and Stephen. We also talking about the issue of constitutional court and also another issue with the constitutional court with another minor. Today, the minor is the procedural review, of course. And also, Prof. Susi, if you are interested to collaboration writing with Stephen, that will be published in the Jakarta Post or maybe another prominent newspaper in Williamsburg. Is it possible for us to connect you with the Stephen? I think it will be nice ideas to join collaboration writing, opinions, maybe in Jakarta Post, Bangkok, and so on and so forth. And it will be nice present or gift for the Constitutional Court anniversary this year. So if you very interested with this issue regarding the procedural comparison between the United States of America and Indonesia, feel free to contact me. I will give the Stephen contact to you and you can discuss together. Again, I offer the microphone to Pak Charles to close this event. Silakan Pak Charles.
Okay, thank you, Prof. Susi and Stephen. Very interested explanation. Although my question is not answer all of point, and I think what Ari said, I hope Prof. Susi and Stephen will collaborate to make a journal or opinion maybe in one of Indonesian newspaper. Hari said Jakarta Post, and Prof. Susi published article with Stephen is one of what we said commitment Pusako and Stephen and William and Mary to make collaboration publishing in Indonesia, and I hope it will be implemented with Prof. Susi and Stephen. And yes, thank you for all of your explanation and your substantial material for us. Thank you, Prof. Thank you,
Thank
Stephen.
you, and Charles. Thank you, Stephen.
Yes, thank you. Honored to speak with